This program is being brought to you by the Hudson Council on Aging. Hello to all of you watching on HUD TV. The views and opinions expressed are those of the author and do not necessarily reflect the official policy or position of the Hudson Cable Access or Hudson Council on Aging. Hello everyone, I'm John Horrigan and welcome to Journey Through the Past. In this edition, It's My Seat, the story of African American women who refused to give up their seat for a white person. Discretion is strongly advised. I now must advise all who are viewing this presentation that I will be using two outdated terms that were predominant in historical records, and they may be offensive to you. I will pause now so you have time to stop viewing this presentation and safely move away. Those two terms are Negro and colored people. Now, these two antiquated terms show up in historical records and court transcripts that we'll be reviewing. For instance, we're going to be reading transcripts from the Browder versus Gale case of 1956, and they even show up in some esteemed national civil rights organizations, such as the NAACP, which is an acronym for the National Association for the Advancement of Colored People. And I will attempt to use African American in place of these terms. The program is called It's Her Seat, or It's My Seat. This is a chronology of the struggle for civil rights endured by selective African American women with a focus on the events that led up to the Montgomery Bus Boycott in 1955. They took a stand for equal rights by remaining seated. Now, there were and still are millions of acts of discrimination that have been and still are committed against African American males as well as African American females. The enforced segregation events that took place in Montgomery, Alabama during 1955 are just a microcosm of the hostilities that African Americans have had to endure for over 400 years. My information is gleaned from various resources, including biography.com, history.com, blackpast.org, nationalhumanitiescenter.org, wikipedia.org, civilandhumanrights.org, the New York Times, Smithsonian, Washington Post, and other various periodicals of the period. We're going to talk about Elizabeth Jennings, Ellen Anderson, Ida B. Wells, Irene Morgan, Sarah Keyes, Mary Fair Burks, Joann Robinson, Georgia Gilmore, Aurelia Browder, Claudette Colvin, Mary Louise Smith, and finally conclude with Rosa Parks. We'll also refer to the Emancipation Proclamation, the 13th, 14th, and 15th Amendments to the U.S. Constitution, the New York Draft Riots of 1863, Reconstruction, the Compromise of 1877, and then three court cases: Plessy versus Ferguson, 1896, Brown versus the Board of Education, 1954, and Browder versus Gale, 1956. Let's start off with Elizabeth Jennings Graham. She was born March in 1827 and passed away on June 5th, 1901. She was an African-American teacher and civil rights figure. In 1854, Graham insisted on her right to ride on an available New York City streetcar at a time when all such companies were private and most operated segregated cars. Her case was decided in her favor in 1855, and it led to the eventual desegregation of all New York City transit systems by the year 1865. Now, she was born free in March 1827, and her parents were Thomas L. Jennings, on the right, and his wife, who was also named Elizabeth, and they had at least 5 children. He was a free black, and she was born into slavery. Thomas Jennings became a successful tailor and an influential member of New York's black community, being the first known African-American holder of a patent in the United States. In 1821, he was awarded a patent from the U.S. government for developing dry scouring, which was a new method to clean clothing. With fees from his patented dry cleaning process, Thomas Jennings bought his wife's freedom, as she was considered an indentured servant until 1827 under the state's gradual abolition law of 1799. But their daughter Elizabeth was thus born free and received an education. Now, with Elizabeth, we're going to talk about the daughter Elizabeth. She later started the city's first kindergarten for African American children, operating it from her home on 247 West 41st Street until her death at age 74 in 1901. Now, Jennings' mother, Elizabeth, was a prominent woman known for penning the speech on the improvement of the mind, which 10-year-old Elizabeth Jennings delivered at a meeting of the Ladies' Literary Society of New York, which was founded in the year 1834 and of which Jennings' mother was a member. The Literary Society was founded by New York's elite black women to promote self-improvement through community activities, reading, and discussion. It was produced and given in 1837, and the speech discusses how the neglect of cultivating the mind would keep blacks inferior to whites and would have whites and enemies believe that blacks do not have any minds at all. Jennings believed the mind was very powerful and its improvement could help with the abolition of slavery and discrimination. Therefore, she called upon Black women to develop their mind and take action. The importance of improving the mind was a consistent theme among elite Black women. By 1854, Jennings became a school teacher and also was the church organist. And she taught at the city's private African free school, which had several locations by this time, and later in the public school system. Now, in the 1850s, the horse-drawn streetcar on rails became a more common mode of transportation, competing with the horse-drawn omnibus in New York City, an omnibus like a wagon. Elevated heavy rail, the next transportation mode in the city, didn't go into service until about 1869. But like the omnibus lines, the streetcar lines were owned by private companies, and their owners and drivers could refuse service to any passengers and enforce segregated seating. On Sunday, July 16, 1854, Elizabeth Jennings went to the First Colored Congregational Church, where she was an organist. As she was running late, she boarded a streetcar of the 3rd Avenue Railroad Company at the corner of Pearl Street and Chatham Street in New York City. That's the location today. Now, the car didn't carry the requisite sign reading, "Colored people allowed in this car," but the driver pulled over to allow Jennings and a companion to board. However, the conductor, not the driver, who was responsible for collecting fares, physically blocked Jennings from entering the car once she stepped onto the platform, and an altercation ensued. The conflicting signals given by the driver, who pulled over to let Elizabeth on, and the conductor, who stopped her from boarding, show just how arbitrarily segregation was enforced at the time. By her own account, published in the New York Tribune a few days later, Jennings stated that the police officer called to the scene sided with the conductor, even though she was the one that had been assaulted. The conductor ordered her to get off. When she refused, the conductor tried to remove her by force. Eventually, with the aid of a police officer, Jennings was ejected from the streetcar. She was hurled onto the muddy, smelly street in New York City wearing her best Sunday clothes. Now, Horace Greeley, a great writer from the New York Tribune, commented on the incident in February of 1855. This is Greeley's article. "She got upon one of the company's cars last summer on the Sabbath to ride to church. The conductor undertook to get her off, first alleging the car was full. When that was shown to be false, he pretended the other passengers were displeased at her presence. But when she insisted on her rights, he took hold of her by force to expel her. She resisted. The conductor got her down on the platform, jammed her bonnet, soiled her dress, and injured her person. Quite a crowd gathered, but she effectually resisted. Finally, after the car had gone on further, with the aid of a policeman, they succeeded in removing her." This is Elizabeth's exact words. "I held my gloved hand up to the driver, and he stopped the cars. We got on the platform when the conductor told us to wait for the next car. I told him I could not wait, as I was in a hurry to go to church. He insisted upon my getting off, but I did not get off. He waited a few minutes when the driver, becoming impatient, said to me, 'Well, you may go in, but remember, if the passengers raise any objections, you shall go out. Whether or not, I'll put you out.' I told him not to lay his hands on me. He took hold of me, and I took hold of the window sash and held on. He pulled me until he broke my grasp, and I took hold of his coat and held on to that, but previously he had dragged my companion out. She was all the while screaming for him to let go of me. A crowd gathered. The driver then went to his horses. I went again into the car. The conductor said, 'You shall sweat for this.' He then told the driver to drive as fast as he could and not to take another passenger in the car to drive until he saw an officer or a station house. We saw an officer at the corner of Walker and Bowery, and he, without listening to anything that I had to say, thrust me out and then pushed me down and tauntingly told me to get redress if I could. I would have come up myself, but I'm quite sore and stiff from the treatment that I received from those monsters in human form yesterday afternoon." The incident sparked an organized movement among Black workers to end racial discrimination on streetcars, led by notables such as Jennings' father, and also, pictured here in the upper right, Reverend James W.C. Pennington and Reverend Henry Highland Garnett, lower right. Her story was publicized by Frederick Douglass in his newspaper, and it received national attention. Now, Jennings' father filed a lawsuit on behalf of his daughter against the driver, the conductor, and the Third Avenue Railroad Company in Brooklyn, where the Third Avenue Company was headquartered. This was one of 4 streetcar companies franchised in the city and had been in operation for about a year. Now, she was represented by the law firm of Culver, Parker, and Arthur. Her case was handled by the firm's 20-year-old junior partner, Chester A. Arthur, who would become a future U.S. president. You can see him in his youth on the left, and then as president on the right. Now, I must say this about Arthur. He vetoed the first version of the 1882 Chinese Exclusion Act, arguing that his 20-year ban on Chinese immigrants to the United States violated the Burlingame Treaty. But then he signed a second version, which included a 10-year ban. So in 1855, the court ruled in Elizabeth Jennings Graham's favor. In his charge to the jury, Brooklyn Circuit Court Judge William Rockwell declared, "Colored persons, if sober, well-behaved and free from disease, had the same rights as others and could neither be excluded by any rules of the company nor by force or violence." The jury awarded Jennings damages in the amount of $250, which is roughly comparable today to $8,000, anywhere from $8,000 to $12,000. And they also gave her $22.50 in court costs. The next day, the Third Avenue Railroad Company ordered its cars desegregated. However, the decision did not apply to all of the city's streetcar lines, which were individually owned and operated. And this was long before the Unified Metropolitan Transportation Authority came into existence, the MTA. And each line then had to be challenged separately in court. In an effort to avoid confrontations like the one between Elizabeth Jennings and the Third Avenue line's conductor, the Sixth Avenue Railroad increased the number of its cars available to African Americans beginning in October 1854. As important as the Jennings case was, it didn't mean that all streetcar lines would desegregate. Leading African American activists formed the New York Legal Rights Association to continue the fight. I want to talk about George Thomas Downing, 1819 to 1903, known as Thomas Downing. Also in 1855, Thomas Downing, a well-known African-American caterer, made a mockery of the Sixth Avenue line's segregated system by daring anyone to stop him. He was 64 years old, from riding uptown. They stopped the omnibus, and he was followed by a band of determined supporters who pushed the car forward when the driver refused to go. Now, James W.C. Pennington was arrested and convicted in 1859 for riding in a white-only streetcar operated by 8th Avenue Railroad, and he was represented by the Legal Rights Association, which had been formed by Elizabeth's father, Thomas L. Jennings. Now, he challenged the system successfully and on appeal gained an 1855 ruling by the state Supreme Court that such racial segregation was illegal and must end. By 1865, after starts and stops, all the streetcar companies had desegregated their systems. Now, Elizabeth Jennings married Charles Graham, who lived only to be 37. He died in 1867, and he was from Long Branch, New Jersey. And they were wed on June 16, 1860 in Manhattan. They had a son, Thomas J. Graham, but he was a sickly child who died of convulsions at the age of 1 during the New York draft riots of July 16, 1863. Let's look at the New York draft riots. As the Civil War progressed, New York's anti-war politicians and newspapers kept warning its working-class white citizens, many of them Irish or German immigrants, that emancipation would mean their replacement in the labor force by thousands of freed enslaved people from the South. Facing a dire shortage of manpower in early 1863, Abraham Lincoln's government passed a strict new conscription law, a draft, which made all male citizens between the ages of 20 and 35 and all unmarried men between 35 and 45 subject to military duty. Though all eligible men were entered into a lottery, they could buy their way out of harm's way by hiring a substitute or paying $300 to the government, which is roughly $5,800 today. At the time, the sum was the average yearly salary for the average American worker, making avoiding the draft impossible for all but the wealthiest of men. And compounding the issue, African Americans were exempt from the draft as they were not considered citizens. So the mobs attacked government facilities on July 13, 1863, and then they turned their violence on African Americans. By far, the worst violence was reserved for African American men, a number of whom were lynched or beaten to death with shocking brutality. In all, the published death toll of the New York City draft riots was 119 people. though estimates of the actual number of people killed has reached as high as 1,200. With the assistance of a white undertaker, the Grahams slipped through mob-filled streets and buried their deceased child in Cypress Hill Cemetery in Brooklyn. The funeral service was read by Reverend Morgan Dix of the Trinity Church on Wall Street. Now, after the New York draft riots, there were numerous attacks against the African-American community in New York. So the Grahams left Manhattan with her mother to live with her sister Matilda in Monmouth County, New Jersey, in or near the town of Eaton. Charles died in 1867 while they were living in New Jersey, and Elizabeth, along with her mother and sister, moved back to New York City in the late 1860s or 1870. Graham lived her later years at 247 West 41st Street, and she founded and operated the city's first kindergarten for Black children in her home. She died on June 5th, 1901 at the age of 74, and according to her tombstone, she was buried in Cypress Hill Cemetery along with her son and husband. In 2007, New York City co-named a block of Park Row as Elizabeth Jennings Place. On January 2nd, 2018, the first biography of Elizabeth Jennings was published, written by Amy Hill Harth. It was entitled Streetcar to Justice, How Elizabeth Jennings Won the Right to Ride in New York, and intended for middle grade to adult readers, and the book was published by HarperCollins Green Willow Books in New York. A note here, we also did a segment on her on The Folklorist. Please check it on YouTube. Now let's talk about the Emancipation Proclamation, 1863. President Abraham Lincoln issued the Emancipation Proclamation on January 1st, 1863, as the nation approached its third year of a bloody civil war. The proclamation declared that all persons held as slaves within the rebellious states are, and henceforward, shall be free. Now, it applied only to states that had not seceded from the United States, leaving slavery untouched in the loyal border states and territories. It also expressly exempted parts of the Confederacy, that is, the southern secessionist states that had already come under Northern control. Most important, the freedom it promised depended upon a Union victory by the military. Although the Emancipation Proclamation didn't end slavery in the nation, it captured the hearts and imagination of millions of Americans and fundamentally transformed the character of the war. After January 1st, 1863, every advance of federal troops expanded the domain of freedom. Moreover, the proclamation announced the acceptance of Black men into the Union Army and Navy, enabling the liberated to become liberators. And by the end of the war, almost 200,000 Black soldiers and sailors had fought for the Union and freedom. Now let's talk about Charlotte Brown Riker, born 1839, unclear as to what date she passed. She was an American educator and civil rights activist who was one of the first to legally challenge racial segregation in the United States when she filed a lawsuit against a streetcar company in San Francisco in the 1860s after she was forcibly removed from a segregated streetcar. Born in Maryland in 1839, the daughter of James E. Brown, who was born enslaved, and Charlotte Brown, who was a free seamstress. The elder Charlotte Brown purchased her husband's freedom, and in 1850 they were living as free people of color in Baltimore, Maryland, with several children, including Charlotte. Now, sometime between 1850 and 1860, they moved their family to San Francisco, which was booming as a result of the California gold rush, and became a part of that city's burgeoning Black middle class. The Black population of the city at that time was 1,176 people, or about 2% of San Francisco's population. Now, at 8 o'clock in the evening on April 17, 1863, Charlotte Brown took a seat on a horse-drawn streetcar 1 block from her home on Filbert Street in San Francisco. She was on her way to see her doctor, and the streetcar was owned by the Omnibus Railroad Company. And when the streetcar conductor approached her and asked her to leave, Brown said she, quote, had a right to ride and had no intention of leaving the car. In her courtroom testimony, she stated, quote, the conductor went around and collected tickets, and when he came to me, I handed him my ticket, and he refused to take it. It was one of the Omnibus Railroad tickets, one that I had purchased of them previous to that time. He replied that colored persons were not allowed to ride. I told him I had been in the habit of riding ever since the cars had been running. I answered that I had a great ways to go, and I was later than I ought to be. The conductor, named Thomas Dennison, asked her several times to leave, and each time she refused. Finally, when a white woman objected to her presence, he grabbed her by the arm and escorted her off the car. Her father, James E. Brown, hired attorney Wc Barnett, and Charlotte Brown brought a lawsuit against the Omnibus Railroad Company for $200. Now, African Americans had just won the right to testify against whites that same year. So, Charlotte Brown versus the Omnibus Railroad Company. The case took 2 years, 3 years almost to litigate, 1863 to 1865. The Omnibus Railroad argued that its conductor's action was justified because racial segregation protected white women and children who might be fearful or repulsed by riding in the same car as African Americans. The conductor, Dennison, was convicted in criminal court of assault and battery against Charlotte Brown. Brown's civil case was tied up in appeals for the next 2 years. In one retrial, the jury awarded Brown only 5 cents, the price of the streetcar ticket. Meanwhile, just 3 days after the first trial, Brown was ejected from yet another streetcar and brought a second lawsuit against Omnibus, this time for $3,000, and she would even try it a third time. So finally, in October 1864, her case was tried in a higher court, and in his judgment of October 5th, 1864, Judge Orville C. Pratt of the 12th District Court upheld the earlier verdict in favor of Charlotte, ruling that excluding passengers from streetcars because of their race was illegal. He had, quote, no desire in his ruling to perpetuate a relic of barbarism. Now, here's a racist editorial cartoon that was published in San Francisco in 1865 after Charlotte won a lawsuit against the segregated San Francisco streetcar company Omnibus. And in January of 1865, a jury awarded Charlotte Brown $500. Let's look at Mrs. Ellen Anderson, born, we think, around the year 1829, not sure of the year she passed. But it's late in the morning of Friday, June 17, 1864, when a well-dressed colored woman, about 35 years of age, stood at the corner of Broadway and 8th Avenue in New York City. She was tired and unwell and wanted nothing so much as to get home. She was dressed in deep mourning. Not long before, she had received official notice that her husband, Sergeant William Anderson from Company F 26th USCT, had accidentally drowned while on the course of duty at Beaufort, South Carolina. Car number 2 of the 8th Avenue Railway drew to a halt, and Mrs. Ellen Anderson mounted the horse-drawn car. She sank onto the bench, glad to get off her feet, and then reached for her purse to pay the fare. But the conductor, rather than taking her money, told her she would have to get off. The smaller, more rickety car, clearly marked as for colored patrons, would be by shortly. Well, out on the street, Ellen Anderson had no choice but to wait for the colored car. But she was angry now, and she wasn't going to let this outrage pass unchallenged. The very next day, letters from eyewitnesses began to appear in the press. A vocal portion of the public, it seemed, agreed that injustice had been done. She went to see Charles C. Whitehead, a white lawyer known for welcoming colored clients, to see what her options were. She found that there was no law prohibiting a railroad company from making rules regarding the use of its cars. Their charter, however, requires that they provide service for the entire population. About 10 years earlier, a ruling was made that as long as adequate service was made available to colored patrons, the service could be segregated. Separate but adequate, you might say. Now, Anderson brought a suit against the police officer who had aided a conductor in removing her from the streetcar. In the court transcript, this is exact. The case of Ellen Anderson, the widow of Sergeant Anderson of Company F and the 26th Colored Regiment, who was forcibly ejected by Police Officer Tyler from one of the cars of the 8th Avenue Railroad, came before the police commissioners this Wednesday morning, a charge of assault having been preferred at her instance against the officer and of breaking the police regulations. Mr. Charles E. Whitehead, attorney, acting for William Curtis Noyes, Esquire Counsel, appeared for the complainant. Her testimony, quote, I am a widow of Sergeant Anderson of Company F, 26th Regiment, who died in discharge of his duty at Beaufort, South Carolina. I was going up home and standing at the corner of Broadway when car number 2 of the 8th Avenue Railroad came up. I got in. The conductor came up and said I could not ride in it. I told him I was sick and wished to go home. He said there would be another car along soon. I told him I wished to ride in that. He started up and put his hands on me. I told him not to touch me. Then he went out and brought in a policeman. This is the man here, she points to him. He came in and told me there would be another car along soon. I said I knew nothing about another car and had a right to ride there as well as anywhere else. He said I could not ride and must go out, and then got hold of me and dragged me and called to the conductor for assistance. The conductor came, and they got me off the seat. I got hold of the straps of the car, and then they both pulled me and dragged me so that I was very sore, and they tore my hand and at least succeeded in dragging me into the street. The conductor said he did not care for me or my husband. I had money with me to pay my fare. Nobody asked me for any money. I had a basket in my hand. So, the directors of the 8th Avenue line said that they had established no policy regarding separate cars. It was a decision of lower management, simply a development of how things were done, rather than a company policy. C.A. Runkle, Esquire, lawyer, confirmed the complainant's statement as to the manner of her ejection and the parties engaged in it, and in answer to a question by defendant, said there was no more violence used than was necessary to take her out, i.e., that's how we normally took black people off of cars. J.P. Cummings, Esquire, a director of the 8th Avenue Railroad, said there was no order excluding colored citizens from the use of the 8th Avenue Railroad cars, and on cross-examination said he did not know there were signs on the road saying colored people were allowed to ride in certain cars only. That's a blatant lie, or an incompetent buffoon that didn't know what was going on in his own company. And he said that no orders had been issued by the board to the conductors to reject colored people. Again, a lie, or he's totally disconnected from his own firm. Attorney Charles Whitehead suggested that they, quote, ask what right these conductors have to call on police officers to help them do their dirty work, and what right the police officers have to lay their hands on anyone who is not an offender against the law. Quote, it is a question whether the railway companies may, by their charters, exclude colored people, but it is not a legal obligation for them to do so. And it is no offense to law by a colored person to be found in a public conveyance. Then he says, I infer that any officer who lends himself to this business is personally liable to a prosecution for assault and battery. Ellen Anderson won that case. Let's look at the 13th Amendment to the U.S. Constitution, 1865. In the aftermath of the Civil War, it abolished slavery in the United States. The 13th Amendment states, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Now the case of Mary Ellen Pleasant. We think she was born anywhere between the year 1812 and 1817. We know she passed in 1904. She was a 19th century American entrepreneur, a financier, a real estate magnate, and an abolitionist. And she identified herself as a capitalist by profession. She worked on the Underground Railroad and helped bring it to California during the Gold Rush era. Now, she was a lover, some say, friend and financial supporter of John Brown, and well known in abolitionist circles. John Brown had the insurrection at Harper's Ferry. He was an abolitionist. So after the Civil War, she won several civil rights victories, one of which was cited and upheld in the 1980s and resulted in her being called the mother of human rights in California. Now, when Mary Ellen arrived in San Francisco, she passed as white, using her first husband's name among the whites, and took jobs running exclusive men's eating establishments, starting with the Case and Heiser. She met most of the founders of the city as she catered lavish meals, and she benefited from the tidbits of financial gossip and deals usually tossed around at the tables. She's a good listener. She engaged a young clerk named Thomas Bell at the Bank of California, and they began to make money based on her tips and guidance. Now, Thomas made money of his own, especially in quicksilver, and by 1875, they had together amassed a $30 million fortune, which today is roughly $647 million. The partnership, though, was seen by many as illicit, and the mansion she built in San Francisco for herself and Bell and his family was thought to be a brothel. Now, Pleasant didn't conceal her race from other blacks and was adept at finding jobs for those brought in by the Underground Railroad. And she left San Francisco from 1857 to 1859 to help John Brown, and she was said to have actively supported his cause with money and work. In fact, there was a note from her, it's believed, in Brown's pocket when he was arrested after the Harper's Ferry incident, and it was only initialed as MEP. And this is her words. She said in that letter, "The axe is laid at the foot of the tree. When the first blow is struck, there will be more money to help." Now, after the Civil War, Mary Ellen Pleasant publicly changed her racial designation in the city directory from white to black, and this caused a little stir among some whites. She began a series of court battles to fight laws prohibiting blacks from riding trolleys and other such abuses. She filed 2 lawsuits, the first against the Omnibus Railroad Company, and it was withdrawn after the company promised to allow African Americans to board their streetcars. The second case, Pleasant versus North Beach and Mission Railroad Company, went to the California Supreme Court and took 2 years to complete. In the city, the case outlawed segregation in the city's public conveyances. However, at the state Supreme Court, the damages awarded against her at the trial court were reversed and found excessive. Now let's look at the 14th Amendment to the United States Constitution, ratified in 1868. It granted citizenship to all persons born or naturalized in the United States, including former enslaved people, and guaranteed all citizens equal protection of the laws. One of the 3 amendments passed during the Reconstruction Era to abolish slavery and establish civil and legal rights for Black Americans, it would become the basis for many landmark Supreme Court decisions over the years. Now let's look at Catherine Brown, born 1840, passed 1883. She was a U.S. Senate employee in charge of the ladies' retiring room. On February 8, 1868, Brown boarded a train to travel from Alexandria, Virginia to Washington, D.C., and she entered, quote, what they call the white people's car. As she was boarding, a railroad policeman told her to move to a different car. He told her the car she had entered was for ladies and no damned, that's the N-word, was allowed to ride in that car. Never was and never would be. She replied, this car will do. The railroad police officer and another employee grabbed Brown, and after a violent struggle that lasted 6 minutes, in which she was beaten and kicked, and they threw her on the boarding platform, dragged her along the platform, and threatened to arrest her. Brown's injuries were so severe that she was bedridden for several weeks and spit up blood. Senators Charles Sumner and Justin Morrill called for a formal investigation, and Senator Charles Drake agreed, and a resolution was passed on February 10th, and Senate committee heard testimony later that month. Now, Brown sued the railway company for damages, and she was awarded $1,500 in district court. The railway company appealed, and the case eventually went before the U.S. Supreme Court. On November 17, 1873, in an opinion delivered by Justice David Davis, the court held that racial segregation on the railroad line was not allowed under its congressional charter, which stated, quote, no person shall be excluded from the cars on account of race. Davis dismissed the company's separate but equal argument as an ingenious attempt to evade a compliance with the obvious meaning of the requirement of the 1863 charter that had been decided in favor of Charlotte Brown. The court held that white and black passengers must be treated with equality in the use of the railroad's cars, and Kate Brown recovered from her injuries and remained a Senate employee until the year 1881. Now let's look at the 15th Amendment to the U.S. Constitution, ratified in 1870. It states, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. It granted African American men, not women, the right to vote, and it was adopted into the U.S. Constitution in 1870. But despite the amendment by the late 1870s, discriminatory practices were used to prevent blacks from exercising their right to vote, especially in the South. And it wasn't until the Voting Rights Act of 1865 that legal barriers were outlawed at the state and local levels if they denied African Americans their right to vote under the 15th Amendment. Let's look at the Reconstruction Era. That was the period in American history that lasted from 1865 to 1877 following the American Civil War, and it marked a significant chapter in the history of civil rights in the United States. Reconstruction ended the remnants of Confederate secession and abolished slavery, making the newly freed slaves citizens with civil rights, ostensibly guaranteed by 3 new constitutional amendments, 13th, 14th, and 15th. But Reconstruction also refers to the attempt to transform the 11 Southern former Confederate states as directed by Congress and the role of the Union states in that transformation. Compromise of 1877, This led to the withdrawal of federal troops from the South, and Democrats consolidated control of state legislatures throughout the region, effectively marking the end of Reconstruction. And then they basically used the former slaves as indentured servants, put them in debt, loaning them tools and seeds so they could farm, but then charging them exorbitant rates along with interest. They were still slaves. Now, Southern Black people saw the promise of equality under the law embodied by the 13th Amendment, 14th Amendment, and 15th Amendment to the Constitution receding quickly in a return to disenfranchisement and other disadvantages as white supremacy reasserted itself across the South. Let's look at Sally Robinson, born in the year 1851. We're not sure of the year she passed. She was a 19th century African-American civil rights activist, and on the evening of May 22nd, 1879, Sally Robinson, a 28-year-old Black woman, bought 2 first-class tickets at Grand Junction, Tennessee, for a train trip to Lynchburg, Virginia. Shortly after midnight, she and her nephew, Joseph Robinson, described as a young Black man of light complexion, light hair, and light blue eyes, boarded the train and started into the parlor car. The conductor held Robinson back, she said, bruising my arm and jerking me roughly around, and pushed her into the smoking car. A few minutes later, when Joseph informed the conductor that he was Robinson's nephew and was an African American, the conductor looked surprised. In that case, he said, they could go into the parlor car at the next stop. The Robinsons finished the ride in the parlor car, but filed complaints with the railroad about their treatment and then sued for $500 under the Federal Civil Rights Act of 1875. At trial, the conductor testified that he had thought Joseph to be a white man with a Black woman, and his experience was that such associations were for illicit purposes. The jury found for the railroad, and the Robinsons appealed to the U.S. Supreme Court, where they lost. Let's talk about Ida B. Wells Barnett, born 1862, passed 1931. Quote, and she said this in 1892, "The way to right wrongs is to turn the light of truth upon them." Ida B. Wells Barnett was a prominent journalist, activist, and researcher in the late 19th and early 20th centuries. In her lifetime, she battled sexism, racism, lynching, and violence. As a skilled writer, Wells Barnett also used her skills as a journalist to shed light on the conditions of African Americans throughout the South. In the 1890s, Wells documented lynching in the United States in articles and through a pamphlet called Southern Horrors, Lynch Law in All Its Phases, investigating frequent claims of whites that lynchings were reserved for Black criminals only. Not true. She exposed lynching as a barbaric practice of whites in the South used to intimidate and oppress African Americans. A white mob destroyed her newspaper office and her presses as her investigative reporting was carried nationally in Black-owned newspapers. On May 4th, 1884, a train conductor with the Chesapeake and Ohio Railroad ordered Ida Wells to give up her seat in the first-class ladies' car and move to the smoking car, which was already crowded with other passengers. The previous year, the Supreme Court had ruled against the Federal Civil Rights Act of 1875, which had banned racial discrimination in public accommodations. This verdict supported railroad companies that chose to racially segregate their passengers. When Ida B. Wells refused to give up her seat, the conductor and 2 men dragged her out of the car. Wells gained publicity in Memphis when she wrote a newspaper article for The Living Way, a Black church weekly, about her treatment on the train. In Memphis, she hired an African-American attorney to sue the railroad. And when her lawyer was paid off by the railroad, she hired a white attorney. She won her case on December 24th, 1884, when the local circuit court granted her a $500 award. The railroad company appealed to the Tennessee Supreme Court, which reversed the lower court's ruling in 1887, and Wells was ordered to pay court costs. Her reaction to the higher court's decision revealed her strong convictions on civil rights and religious faith, as she responded, quote, "I felt so disappointed because I had hoped such great things from my suit for my people. Oh God, is there no justice in this land for us?" Wells would go on to create the National Association of Colored Women in 1896, and she was a founding member of the NAACP, and she ran for a seat in the Illinois State Senate and worked with the National Equal Rights League. Let's look at Plessy versus Ferguson, 1896. This case stemmed from a June 7, 1892 incident in which a train passenger by the name of Homer Plessy, depicted below, refused to sit in a car for black people after purchasing a first-class ticket. Now, this was a deliberate test case that was planned to see how the railroad would react to Homer Plessy. And he was a man of mixed race. He was called an octoroon, i.e. he was 7/8 white and 1/8 black ancestry. And he was born a free man, and he was a fair-skinned man of color. So, however, under Louisiana law, he was classified as black and thus required to sit in the colored car. Rejecting Plessy's argument that his constitutional rights were violated, the Supreme Court ruled that a law that implies merely a legal distinction between white people and black people was not unconstitutional, a setback. In 1896, the Supreme Court ruled in Plessy versus Ferguson that racially segregated public facilities were legal so long as the facilities for black people and whites were equal, Jim Crow laws. The ruling constitutionally sanctioned laws barring African Americans from sharing the same buses, sharing the same schools, and sharing the same public facilities as whites, again, known as Jim Crow laws, and it established the separate but equal doctrine that would stand for the next 6 decades. Now let's talk about Paulie Murray, born 1910, passed 1985, and her partner Adeline McBean. I have no birth or death records on her, unfortunately. But Paulie was a civil rights activist. She became a lawyer, a women's rights activist, an Episcopal priest, and author. And 15 years before Rosa Parks in Montgomery, these 2 young black women were arrested on a bus near Petersburg, Virginia. And like Rosa, both women were already actively engaged in the struggle for racial equality. And by the time they boarded an old bus bound for Durham, North Carolina in late March 1940, Paulie Murray and her partner Adeline McBean had long discussed how they could most effectively challenge racial segregation. Now, the poor condition of their bus gave them the opportunity to translate their thoughts into action. Seated near the back of the bus, directly over a wheel, and that's awful if you ever sit in the back of a bus over a wheel, the 2 young women suffered with each and every bump. And when Adeline began to feel a sharp pain in her side, she and Paulie occupied seats in the middle of the bus, and the driver told them to move back, and they refused. After a lengthy debate with the driver and local police officers, the 2 women were arrested, and Paulie wrote her friends soon after her arrest, quote, "We did not plan our arrest intentionally. The situation developed, and having developed, we applied what we knew of satyagraha on the spot." Now, Gandhi used the word satyagraha, combining the Sanskrit for truth and holding firm to refer to his particular approach to nonviolent civil disobedience. In 1950, Paulie would publish States' Laws on Race and Color, an examination and critique of state segregation laws throughout the United States. Paulie Murray. Now, Irene Morgan Kirkcaldy, 1917 through 2007. Now, Irene Morgan had been dealing with a recent miscarriage, and she was visiting her mother in Gloucester County, Virginia, to physically and mentally recover from the ordeal. She was hoping to go back home so she could continue working on the production line for the B-26 Marauder, and she boarded a Greyhound to return to Baltimore. This is during World War II. And on July 16, 1944, Irene Morgan boarded the Greyhound bus, and she sat down next to another African-American woman who was carrying an infant. An African-American could not sit next to or across from a Caucasian passenger, but there were no designated black or white seats on the bus. When a white couple boarded the bus at a stop in Middlesex County, Virginia, the bus driver ordered Irene and her seatmate to surrender their seats. Her seatmate immediately retreated to the back of the bus with her infant, but Morgan refused to give up her spot. When Morgan would not move, the bus driver hopped off the bus to grab a sheriff. The sheriff presented Morgan with an arrest warrant, but she tore up the piece of paper and threw it out of the window of the bus. When the sheriff touched her to pull her out of her seat, she kicked him in the groin. The sheriff got off the bus, and a different sheriff was sent on. Quote, she said, "He touched me. That's when I kicked him in a very bad place. He hobbled off, and another one came on. I was going to bite him, but he looked dirty, so I clawed him instead. I ripped his shirt. We were both pulling at each other. He said he would use his nightstick. I said, we'll whip each other." Morgan was arrested and charged with resisting arrest and violating Virginia's Jim Crow transit law. On October 18, 1944, Morgan attended her court case, and she agreed to pay a $100 fine for resisting arrest, but refused to plead to the segregation violation. Since Maryland did not enforce segregation for interstate travel, Virginia's Jim Crow law could possibly not apply to Morgan. Morgan's case, with the help of the NAACP, was taken to the Virginia Supreme Court, and the Supreme Court ruled her in violation of the law. Morgan then took her case to the U.S. Supreme Court and won. Her case, Irene Morgan versus Commonwealth of Virginia, 328 U.S. 373, year 1946, was argued by William H. Hastie, the former governor of the U.S. Virgin Islands and later a judge on the U.S. Court of Appeals for the Third Circuit. And Thurgood Marshall of the NAACP was co-counsel. The U.S. Supreme Court ruled 6-1 in 1946 that Virginia's state law enforcing segregation on interstate buses was unconstitutional. Hastie and Marshall used an innovative strategy to brief and argue the case. Instead of relying upon the Equal Protection Clause of the 14th Amendment, they argued successfully that segregation on interstate travel violated the Interstate Commerce Clause of the U.S. Constitution. Irene Morgan said, "If something happens to you which is wrong, the best thing to do is have it corrected in the best way you can. The best thing for me to do was to go to the Supreme Court." Lilly Mae Bradford, born 1928, passed 2017. She was an American civil rights activist who 4 years before Rosa Parks' more publicized action performed an act of civil disobedience on a city bus in Montgomery, Alabama, for which she was arrested on a charge of disorderly conduct. On May 11th, Bradford saw that the bus driver had punched her ticket for the wrong price. According to Lilly Mae, she said, apparently a costly and frequently occurring error, if it was indeed an error. Bradford asked to be charged the correct price, and after being told twice to return to the back of the bus, she sat down in the front, in the white section. The 20-year-old was going home from her job caring for disabled white children. She had paid for a transfer onto another bus, but as often happened, the driver had punched it in the wrong place, and if she did nothing about it, she would have ended up paying for the mistake, paying twice. Quote, "I thought, if I don't get up and start speaking for my rights, I never will. It was humiliating. It was not dignified. It was off limits to go up to the front of the bus, but I went up there and I told him that my ticket hadn't been punched right. He said," he uses the N-word, go to the back of the bus. And I said, "I will as soon as you give me the right transfer or give me my money back." And then I took a seat in the white folks section. The driver never fixed the punch card, and Bradford never left the front seat. She was arrested for disorderly conduct, booked, fingerprinted, and paid a small fine. She was held by police for disorderly conduct until a neighbor bailed her out. And the arrest followed her throughout her life. She said it had prevented her several times from getting jobs she applied for. In 2006, she commented, "There was always a box that said, 'Do you have a criminal record?' I went for federal clerk positions and I would pass the tests, but I wouldn't get the job. That's when I came to the conclusion that it was because I had a police record." Now let's look at Sarah Louise Keyes Evans, known as Sarah Keyes. Born in 1929. On August 1st, 1952, Women's Army Corps Private First Class Sarah Louise Keyes, age 23, traveled from Fort Dix, New Jersey to her family's home in Washington, North Carolina. During a stop to change drivers, she was told to relinquish her seat to a white Marine and move to the back of the bus. Keyes refused to move, whereupon the driver emptied the bus, directed the other passengers to another vehicle, and barred Keyes from boarding it. When Keyes asked why she shouldn't ride the bus, she was arrested and spent 13 hours in a cell, scared, pacing, and crying. Keyes was eventually ordered to pay a $25 fine for disorderly conduct and was released and put on a bus to her hometown. Her case was brought before the Interstate Commerce Commission and wasn't settled until November 7, 1955. In Sarah Keyes versus Carolina Coach Company, the ICC favored Keyes, ruling the Interstate Commerce Act forbids segregation. She said, quote, "I knew I had been unjustly accused of disorderly conduct. I was willing to prove that I wasn't disorderly. There was nothing disorderly going on that night. My father said when you purchased a ticket, make sure the bus goes straight through with no stops." In other words, nobody could question her. In other words, you wouldn't be hassled by the driver. "I didn't set out to do what I did. It just happened. I wasn't going to get up and walk through a crowd to stand. I was tired. It was around midnight, and you're just anxious to get where you were supposed to be." In retrospect, Sarah was a law-abiding young woman who certainly was not looking for trouble. It found her, and rather than wilt in the face of confrontation, she did like many before her. She rose, stood, and fought with pride and grace. Most importantly, She said she fought with the resolve that America had the willingness to change itself. Sarah Case. Let's look at Mary Fair Burks, born 1914, passed 1991. She was an American educator. In fact, she was a chairperson of the English department at Alabama State College, a scholar and activist during the Civil Rights Movement from Montgomery, Alabama. Burks founded the Women's Political Council, you'll hear me say WPC, in the year 1946, which helped initiate the Montgomery Bus Boycott following the arrest of Rosa Parks in December of 1955. Back to the year 1935, Mary Fair Burks was involved in an incident with a white female motorist that led to her being arrested by a white police officer. The incident demonstrated the prevalence of racism in Montgomery to Burks, which she had felt previously shielded her due to her education level and status. It also inspired Burks to focus her attention towards advocating for racial equality in Montgomery, Alabama, so she founded the WPC, the Women's Political Council. And the WPC focused its efforts around promoting civic involvement, increasing voter registration numbers, and lobbying city officials to address racist policies. Now let's go to Joann Robinson, born 1912, passed 1992. She was an instrumental figure in initiating and sustaining the Montgomery Bus Boycott, and she was also an unspoken critic of the treatment of African Americans on public transportation. In his memoir, Stride Towards Freedom, Martin Luther King said of Joann, apparently indefatigable, she, perhaps more than any other person, was active on every level of the protest. She was born in Culloden, Georgia, and she was the youngest of 12 children. Joann graduated as valedictorian of her high school class and went on to earn her BS from Fort Valley State College, becoming the first person in her family to graduate from college. Robinson taught for 5 years in Macon's public school system, where she was married to Wilbur Robinson for a short time. She then moved to Atlanta, Georgia, to earn her MA in English from Atlanta University. And following a year of study at Columbia University, where she received yet another master's degree, she taught briefly at Mary Allen College in Crockett, Texas, before moving to Montgomery in 1949 to teach English at Alabama State College. In Montgomery, Joann was active in the Dexter Avenue Baptist Church and the Women's Political Council, WPC. In 1949, Robinson was verbally assaulted by a bus driver, cursing her to get off his bus for sitting in the fifth row of the whites-only section on a nearly empty public bus. The whites-only section was completely empty, and she left the bus in tears. Out of fear that the incident would escalate and that the driver would go from verbal abuse to physical, Robinson left the bus. And her response to the incident was to attempt to start a protest boycott against bus segregation in Alabama. However, when Robinson approached fellow WPC members with her story and proposal, she was told that it was a fact of life in Montgomery. In late 1950, she succeeded Mary Fair Burks as president of the WPC and helped focus the group's efforts on bus abuses. Robinson stated in her memoir that, quote, members felt that young concerned women with their futures ahead would benefit by the WPC and that we would help them to organize and select goals and directions for their future. To further her efforts, Robinson met with the mayor of Montgomery, Alabama at the time, William A. Gale. His name will come up in the case with Aurelia Browder. Robinson also met with the Montgomery City Commission, but they weren't interested in what she had to say. And when City Hall's leaders were no help, Joann took matters into her own hands and organized a boycott once again. And she said, quote, people the world over should know that any group, if given equal opportunity in education, employment, civil rights, and the like, can be desirable citizens anywhere with as much to offer as any other group. So after the Supreme Court decision in Brown versus Board of Education, Robinson informed the city's mayor that a bus boycott might ensue if bus service did not improve, but negotiations had yielded little success by late 1955. Let's look at Brown versus Board of Education, 1954. In the case that would become a lawsuit, a plaintiff named Oliver Brown filed a class action suit against the Board of Education of Topeka, Kansas in 1951, after his daughter Linda Brown was denied entrance to Topeka's all-white elementary schools. And that's Linda on the right there. In his lawsuit, Brown claimed that the schools for black children were not equal to the white schools and that segregation violated the so-called Equal Protection Clause of the 14th Amendment, which holds that no state can deny to any person within its jurisdiction the equal protection of the laws. The case went before the U.S. District Court in Kansas, which agreed that public school segregation had a, quote, detrimental effect upon the colored children and contributed to a sense of inferiority, but still upheld the separate but equal doctrine. When Brown's case and 4 other cases related to school segregation first came before the Supreme Court in 1952, the court combined them into a single case under the name Brown versus Board of Education of Topeka. Thurgood Marshall, the head of the NAACP Legal Defense and Educational Fund, served as chief attorney for the plaintiffs. He would later become the first Black Supreme Court justice. So at first, the justices were divided on how to rule on school segregation, with Chief Justice Fred M. Vinson holding the opinion that the Plessy verdict should stand, separate but equal. But in September 1953, before Brown versus Board of Education was to be heard, Vinson died, and President Dwight D. Eisenhower replaced him with Earl Warren, who was then governor of California. Displaying considerable political skill and determination, the new Chief Justice succeeded in engineering a unanimous verdict against school segregation the following year. In the decision issued on May 17, 1954, Warren wrote that, quote, in the field of public education, the doctrine of separate but equal has no place, as segregated schools are inherently unequal. As a result, the court ruled that the plaintiffs were being deprived of the equal protection of the laws guaranteed by the 14th Amendment. In its verdict, the Supreme Court did not specify how exactly schools should be integrated, but asked for further arguments about it. In May 1955, the court issued a second opinion in the case, known as Brown versus Board of Education II, which remanded future desegregation cases to lower federal courts and directed district courts and school boards to proceed with desegregation with all deliberate speed. Though well-intentioned, the court's actions effectively opened the door to local judicial and political evasion of desegregation. While Kansas and some other states acted in accordance with the verdict, many school and local officials in the South defied it. In one major example, Governor Orville Faubus of Arkansas called out the state National Guard to prevent Black students from attending high school in Little Rock, Arkansas in 1957. After a tense standoff, President Eisenhower deployed federal troops, and 9 students, pictured on the right, known as the Little Rock Nine, were able to enter Central High School under armed guard. Though the Supreme Court's decision in Brown versus Board didn't achieve school desegregation on its own, the ruling and the steadfast resistance to it across the South fueled the nascent civil rights movement in the United States. In 1955, a year after the Brown versus Board of Education decision, Rosa Parks refused to give up her seat on a Montgomery, Alabama bus. Now let's talk about Claudette Colvin, born in 1939. She was a pioneer of the 1950s civil rights movement and a retired nurse's aide. Her stand was part of a long history of African-American resistance, as acts of resistance on segregated transportation had been going on for more than a century. When Claudette Colvin's high school in Montgomery, Alabama, observed Negro History Week in 1955, the 15-year-old had no way of knowing how the stories of Black freedom fighters would soon impact her life. Quote, I knew I had to do something. I just didn't know where or when. Colvin got her chance on March 2nd, 1955, when she boarded a bus in downtown Montgomery. She and 3 other Black students were told to give up their seats for a white woman. Colvin, emboldened by her history lessons, refused. Quote, my head was just too full of Black history. It felt like Sojourner Truth was on one side pushing me down, and Harriet Tubman was on the other side of me pushing me down. I couldn't get up. In 1955, Colvin was a student at the segregated Booker T. Washington High School in the city, and she relied on the city's buses to get to and from school because her parents didn't own a car. Now, the majority of customers in the bus system were African American, but they were discriminated against by its custom of segregated seating. On March 2nd, 1955, she was returning home from school, and she sat in the colored section about 2 seats away from an emergency exit in a Capitol Heights bus. If the bus became so crowded that all the white seats in the front of the bus were filled until white people were standing, any African Americans were supposed to get up from nearby seats to make room for whites, move further to the back, and stand in the aisle if there were no free seats in that section. When a white woman who got on the bus was left standing in the front, the bus driver, Robert W. Cleary, commanded Colvin and 3 other Black women in a row to move to the back. The other three moved, but another pregnant woman, Ruth Hamilton, got on and sat next to Colvin. Quote, I knew then and I know now, when it comes to justice, there is no easy way to get it. You have to take a stand and say, this is not right. So the driver then looked at them in his mirror. And this is Claudette now. He asked us both to get up. Mrs. Hamilton said she was not going to get up and that she had paid her fare and that she didn't feel like standing. So I told him I was not going to get up either. So he said, if you're not going to get up, I will get a policeman. And the police arrived and convinced a black man sitting behind the two women to move so that Mrs. Hamilton could move back. But Claudette still refused to move. She was forcibly removed from the bus and arrested by two policemen, Thomas J. Ward and Paul Headley. When Colvin refused to get up, she was thinking about a school paper that she had written that day about the local custom that prohibited blacks from using dressing rooms in order to try on clothes in department stores. Quote, we couldn't try on clothes. You had to take a brown paper bag and draw a diagram of your foot and then take it into the store. Referring to segregation on the bus and the white woman, she said, she couldn't sit in the same row as us because that would mean we were as good as her. Colvin yelled, it's my constitutional right. She was handcuffed, arrested, and forcibly removed from the bus. She again shouted that her constitutional rights were being violated. Quote, but I made a personal statement too, one that Parks didn't make and probably couldn't have made. Mine was the first cry for justice, and a loud one. I wanted the young African-American girls also on the bus to know that they had a right to be there because they had paid their fare just like the white passengers. This is not slavery. We shouldn't be asked to get up for the white people just because they are white. I just wanted them to know the Constitution didn't say that. Two police officers boarded and yanked Claudette out of her seat, dragged her off the bus. And then the police officers who took her to the station made sexual comments about her body and took turns guessing her bra size throughout the ride. Claudette thought that she was going to be raped or beaten with a club. And during the brief jail stay, she said, I remember sitting on a cot without a mattress. I can still vividly hear the keys lock me in. Now, over the years, for example, sources mixed up the facts about her pregnancy, with rumors starting that she had been pregnant at the time of her arrest. In fact, she became pregnant that summer, and her son Raymond was born the following spring. This is one of the reasons why they didn't want her to be a lead in the case that would eventually be Browder versus Gale. Let's talk about Aurelia Shines Browder Coleman, born 1919, passed 1971. She was a civil rights activist, a seamstress, a nurse, a midwife, a teacher, and a businesswoman. And in April 1955, almost 8 months before the arrest of Rosa Parks and a month after the arrest of Claudette Colvin, she was arrested for refusing to give up her bus seat to a white rider. She was born in Montgomery, Alabama, where she resided her entire life, and she was the sole economic supporter of her 6 children after she was widowed. Aurelia completed high school in her 30s and then earned a bachelor's degree in science from Alabama State, where she graduated with honors and became a member of the National Honor Society. And while at Alabama State University, Browder met Joann Robinson, a professor in the English department, fellow civil rights activist, and a member of the Women's Political Council. Robinson described Aurelia as, quote, well-read, highly intelligent, and fearless. Robinson inspired Browder to get involved and tackle the injustices in the transportation system, encouraging her to participate in the lawsuit proposed by the MIA, the Montgomery Improvement Association. Now, prior to her involvement in the Montgomery Bus Boycott, Browder was active in the voter registration campaigns of the 1950s, and she spent time tutoring African Americans who wanted to take the voter registration exam, which was very difficult and deliberately made so specifically for African Americans trying to register to vote. And she also provided transportation to the courthouse for those who wanted to register to vote. Now, Aurelia Browder became associated with several civil rights groups during her time, including the NAACP, the National Association for the Advancement of Colored People, and the SCLC, which was the Southern Christian Leadership Conference that Martin Luther King would go on to lead. Now, she was arrested on April 19th, 1955, again, almost 8 months before Rosa Parks and a month after the arrest of Claudette Colvin, because she sat in the white section of a public city bus in Montgomery, Alabama. And she was convicted and then fined for her alleged crime. Let's look at Mary Louise Smith. Mary Louise Smith Ware, born 1937. And the reason why I'm giving you all the biographies of these women is because they are all going to be involved in the Browder versus Gale case. October 21st, 1955, Mary Louise Smith, age 18, was returning home by way of the Montgomery City bus. And at a stop after Smith had boarded and seated, a white passenger boarded. There was no place for the white passenger to sit, and Smith was ordered to relinquish her seat. She refused. Smith was arrested and charged with failure to obey segregation orders and given a $9 fine, which her father paid. Now, her case was not widely publicized at the time, and she was a housekeeper, and she refused to give her seat to a white passenger because she was already at her wit's end after trekking across town to retrieve money that a client owed her, only to find the family wasn't home. Quote, this is what she said. A lady got on the bus and a man got up for her and wanted me to get up and give up my seat. And that's what really popped it off, because I was not going to stand for almost a mile or more to get down to my next destination. I was upset. I might have said a bad word at the time because I was angry. I just didn't feel like it was right. And now let's look at Rosa Parks. She said, quote, at the time I was arrested, I had no idea it would turn into this. It was just a day like any other day. The only thing that made it significant was the masses of the people joined in. Rosa Parks. Rosa Parks was a civil rights activist who refused to surrender her seat to a white passenger on a segregated bus in Montgomery, Alabama, and her defiance sparked the Montgomery Bus Boycott. And its success launched nationwide efforts to end racial segregation of public facilities. Her bravery led to nationwide efforts to end racial segregation, and she was awarded the Martin Luther King Jr. Award by the National Association for the Advancement of Colored People, and also the Presidential Medal of Freedom and the Congressional Gold Medal. Parks was born Rosa Louise Macaulay on February 4th, 1913 in Tuskegee, Alabama, and her parents, James and Leona Macaulay, separated when Rosa was only 2 years old. Her mother moved the family to Pine Level, Alabama, to live with her parents, Rose and Sylvester Edwards. Now, both of Rosa's grandparents were formerly enslaved people and strong advocates for racial equality, and the family lived on the Edwards farm where Parks would spend her youth. Her childhood brought her early experiences with racial discrimination and activism for racial equality. In one experience, Parks's grandfather stood in front of their house with a shotgun while Ku Klux Klan members marched down their street. Rosa recalled going to the elementary school in Pine Level, where school buses took the white students to their new school and black students had to walk to theirs. Quote, I'd see the bus pass every day, but to me, that was a way of life. We had no choice but to accept what was custom. The bus was among the first ways I realized there was a black world and a white world. Throughout Rosa's education, she attended segregated schools, and she was taught to read by her mother at a young age, and she also attended a segregated one-room school in Pine Level, Alabama, that often lacked adequate school supplies, such as desks. Beginning at age 11, Rosa attended the city's industrial school for girls in Montgomery, and that would be burned down twice by white arsonists. But she became an excellent seamstress. And in 1929, while in the 11th grade and attending a laboratory school for secondary education led by the Alabama State Teachers College for Negroes, Rosa left school to attend to both her sick grandmother and mother back in Pine Level. And she never returned to her studies. Instead, she got a job at a shirt factory in Montgomery. And after marrying in 1932, she earned her high school degree in 1933 with her husband's support. And in 1932, at age 19, Rosa met and married Raymond Parks. He was a barber and also an active member of the NAACP. But the couple never had children. So after graduating high school with Raymond's support, Rosa became actively involved in civil rights issues by joining the Montgomery chapter of the NAACP in 1943, serving as the chapter's youth leader, as well as secretary to the NAACP president, E.D. Nixon, a post she would hold until 1957. I worked on numerous cases with the NAACP, but we did not get the publicity. There were cases of flogging, peonage, murder, and rape. We didn't seem to have too many successes. It was more a matter of trying to challenge the powers that be and to let it be known that we did not wish to continue being second-class citizens. One day in 1943, Parks boarded a bus and paid the fare. She then moved to a seat, but the driver, James F. Blake, told her to follow city rules and enter the bus again from the back door. When Parks exited the vehicle, Blake drove off without her. She already paid her fare. Parks waited for the next bus, determined to never ride with Blake again. On December 1st, 1955, Rosa Parks was arrested for refusing a bus driver's instructions to give up her seat to a white passenger. This is 12 years later. And she later recalled that her refusal wasn't because she was physically tired, but that she was tired of giving in. Quote, "For years, the Black community had complained that the situation was unfair. My resisting being mistreated on the bus did not begin with that particular arrest. I did a lot of walking in Montgomery." And the bus driver was the very same man, James F. Blake, who had left her in the rain 12 years earlier in 1943. After a long day's work at a Montgomery department store where she worked as a seamstress, Parks boarded the Cleveland Avenue bus to go home. She took a seat in the first of several rows that were designated for colored passengers. The Montgomery City Code required that all public transportation be segregated and that bus drivers had the powers of a police officer of the city while in actual charge of any bus for the purposes of carrying out the provisions of the code. While operating a bus, drivers were required to provide separate but equal accommodations for white and black passengers by assigning seats. This was accomplished with a line roughly in the middle of the bus, separating white passengers in the front of the bus and African-American passengers in the back. When an African-American passenger boarded the bus, they had to get on at the front to pay their fare and then get off and reboard the bus at the back door. As the bus Parks was riding on continued on its route, it began to fill up with white passengers, and eventually the bus was full and the driver noticed that several white passengers were standing in the aisle. The bus driver stopped the bus and moved the sign separating the two sections back one row, asking 4 black passengers to give up their seat. The city's bus ordinance didn't specifically give drivers the authority to demand a passenger to give up a seat to anyone, regardless of color. However, Montgomery bus drivers had adopted the custom of moving back the sign separating black and white passengers, and if necessary, asking black passengers to give up their seats to white passengers. The first 4 rows of seats on each Montgomery bus were always reserved for whites, and if the black passenger protested, the bus driver had the authority to refuse service and could call the police to have them removed. Rosa said, "When that white driver stepped back toward us, when he waved his hand and ordered us up and out of our seats, I felt a determination cover my body like a quilt on a winter night." By Parks' account, Blake said, "Y'all better make it light on yourselves and let me have those seats." The driver wanted us to stand up, the 4 of us. We didn't move at the beginning, but he says, "Let me have these seats." And the other 3 people moved, but I didn't. When he saw me still sitting, he asked if I was going to stand up. And I said, "No, I'm not." And he said, "Well, if you don't stand up, I'm going to have to call the police and have you arrested." I said, "You may do that. I would have to know for once and for all what rights I had as a human being and a citizen." Parks moved, but towards the window seat. She did not get up to move to the redesignated colored section. Parks later said about being asked to move to the rear of the bus, quote, "I thought of Emmett Till, a 14-year-old African-American who was lynched in Mississippi just a few months earlier, after being accused of offending a white woman in her family's grocery store, whose killers were tried and acquitted, and I just couldn't go back." And later on, the woman actually confessed that she made up the story many, many years after the event. 2 policemen came on the bus, and one asked me if the driver had told me to stand. He wanted to know why I didn't stand, and I told him I didn't think I should have to stand up. I asked him, "Why did they push us around?" He said, "I don't know, but the law is the law, and you are under arrest." I only know that as I was being arrested, that it was the very last time that I would ever ride in humiliation of this kind. I did not want to be mistreated. I did not want to be deprived of a seat that I had paid for. It was just time. There was opportunity for me to take a stand to express the way I felt about being treated in that manner. I had not planned to get arrested. I had plenty to do without having to end up in jail. But when I had to face that decision, I didn't hesitate to do so because I felt that we had endured that too long. The more we gave in, the more we complied with that kind of treatment, the more oppressive it became. That was an interview from NPR 1992. So the police arrested Parks at the scene, and they charged her with violation of Chapter 6, Section 11 of the Montgomery City Code. She was taken to police headquarters, where later that night she was released on bail. Her arrest, though, sparked the Montgomery Bus Boycott, and it would lead to other boycotts, sit-ins, and demonstrations, many of them led by Martin Luther King Jr., in a movement that would eventually lead to the toppling of Jim Crow laws across the South. Members of the African-American community were asked to stay off city buses on Monday, December 5th, 1955, the very day of Parks's trial, in protest of her arrest. People were encouraged to stay home from work or school, take a cab, or walk to work. With most of the African-American community not riding the bus, organizers believed a longer boycott might be successful. The Montgomery Bus Boycott, as it came to be known, was a huge success, lasting for 381 days and ending with the Supreme Court ruling declaring segregation on public transit systems to be unconstitutional. E.D. Nixon began forming plans to organize a boycott of Montgomery city buses on December 1st, the very evening that Rosa was arrested. Joann Robinson stayed up all night copying over 35,000 handbills by a mimeograph machine at Alabama State College. Now, she had to do that in secret. She stayed up all night because if she got caught, she'd be fired. And ads were placed in local papers, and these handbills were printed and distributed in Black neighborhoods. The Montgomery Bus Boycott was not a spontaneous event, however. Various organizations in Montgomery, including the NAACP, the MIA, Montgomery Improvement Association, and the Women's Political Council, WPC, had been waiting for the right moment to begin protest. And again, Joann Gibson Robinson, led this actually on December 3rd, 1955, 2 days after Rosa's arrest. And Joann was also targeted with several acts of intimidation. In fact, one local police officer threw a stone through her window and another poured acid on her car. So on the day of Rosa's trial, December 5th, 1955, the WPC distributed the 35,000 leaflets. And this is what the handbill actually read. Let's read it. Another woman has been arrested and thrown in jail because she refused to get up out of her seat on the bus for a white person to sit down. It is the second time since the Claudette Colvin case that a Negro woman has been arrested for the same thing. This has to be stopped. Negroes have rights too, for if Negroes did not ride the buses, they could not operate. 3/4 of the riders are Negro, yet we are arrested or have to stand over empty seats. If we do not do something to stop these arrests, they will continue. The next time, it may be you or your daughter or mother. This woman's case will come up on Monday. We are, therefore, asking every Negro to stay off the buses Monday in protest of the arrest and trial. Don't ride the buses to work, to town, to school, or anywhere on Monday. You can afford to stay out of school for one day if you have no other way to go except by bus. You can also afford to stay out of town for one day. If you work, take a cab or walk. But please, children and grown-ups, don't ride the bus at all on Monday. Please stay off all buses Monday. That's the handbill. It was effective. So in the morning of December 5th, a group of leaders from the African-American community gathered at the Mount Zion Church in Montgomery to discuss strategies and determined that their boycott effort required a new organization and strong leadership. They formed the MIA, the Montgomery Improvement Association, electing Montgomery newcomer Martin Luther King Jr. as minister of the Dexter Avenue Baptist Church. And they chose King to lead the boycott because the young minister was very new to Montgomery and the city fathers had not had the time to intimidate him. And the MIA believed that Parks's case proved an excellent opportunity to take further action to create real change. So when Parks arrived at the courthouse for trial that morning with her attorney, Fred Gray, pictured here, she was greeted by a bustling crowd of around 500 local supporters who rooted her on. Following a 30-minute hearing, Parks was found guilty of violating a local ordinance and was fined $10 as well as a $4 court fee. Inarguably, the biggest event of the day, however, was what Parks's trial had triggered. The city's buses were, by and large, empty. Some people carpooled and others rode in African-American operated cabs, but most of the estimated 52,000 African-American commuters living in the city of Montgomery at that time had opted to walk to work that day, some as far as 20 miles. Due to the size and scope of, and loyalty to, boycott participation, the effort continued for several months. The city of Montgomery had become a victorious eyesore, with dozens of public buses sitting idle, ultimately severely crippling finances for its transit company. With the boycott's progress, however, came strong resistance. Now I'd like to talk about some of the people who were key in sustaining the bus boycott. One was Mother Pollard, born, we think, 1882, perhaps 1885, and passing perhaps in the year 1962. That's a picture of her on the right. She was dubbed Mother because of her age. Her real first name is unknown. She was an American church elder who participated in the 1955-1956 Montgomery Bus Boycott, and she's been called a civil rights hero for her tenacity in soothing the spirit of her pastor, the new Reverend Dr. Martin Luther King Jr. So she was an elder of the Dexter Avenue Baptist Church during the time of the bus boycott. And Martin Luther King Jr. recounted in his writings that after several weeks of walking to her destinations rather than taking the bus, he suggested to Mother Pollard, then about the age of 72, that she might take the bus again for the sake of her health. She replied, "My feet is tired, but my soul is rested." And she also told him, "God's going to take care of you." Let's talk about Georgia Gilmore. She was a Montgomery cook, midwife, and activist whose secret kitchen fed the civil rights movement. So when Martin Luther King and others held meetings of the Montgomery Improvement Association at the Holt Street Baptist Church, Georgia Gilmore was there, selling fried chicken sandwiches and other foods to the African-American men and women gathered there who'd pledged not to use the city's buses until they were desegregated. And Gilmore poured those profits back into the MIA. She was born in 1920 and passed in 1990, and that's her photograph on the right. So she organized Black women to sell pound cakes and sweet potato pies, fried fish and stewed greens, pork chops, mac cheese, and rice, and they sold them at beauty salons, cab stands, and churches. And she offered these women, many of whose grandmothers were born into slavery, a way to contribute to the cause that would not raise suspicions of white employers who might fire them from their jobs or white landowners who might evict them from their rented houses. And by the way, her kitchen was known as the best place to eat in Montgomery. In fact, when she opened a restaurant later, she had white and black people eat side by side next to each other. The money they raised helped pay for the alternate transportation system that arose in Montgomery during the 381-day bus boycott. Hundreds of cars, trucks, and wagons that ferried Black workers to and from their jobs across town each day. And Gilmore's cooking helped pay for the insurance, gas, wagons, and vehicle repairs that kept that system going. She called her group of women who worked with her in this project the Club from Nowhere because, as Betty Gilmore, George's sister, later said, it was like, where did this money come from? It came from nowhere. She fearlessly denounced the white bus driver who had kicked her off a city bus and began her personal boycott a year earlier in 1954. Quote, "When I paid my fare and they got the money, they don't know Negro money from white money." The testimony made Gilmore a hero to local Blacks, but in the white world, she became a pariah. Gilmore lost her job as a cook at the National Lunch Company, and Reverend King, who is said to have loved her pork chops, said, "Well, why don't you go into business for yourself?" King lived a few blocks from Gilmore, and she was a fan of her cooking and her activism. So whenever VIPs would come into town, Martin would always make Miss Gilmore cook up a batch of her chicken. So she did, and with King's support, Gilmore turned her house into an informal restaurant. Let's talk about Theodore Lacey, born 1932. She was teaching science at George Washington Carver High School, and she was very active in the boycott, working, as she says, as a gopher. She attended meetings and typed press releases for the movement, and many of the participants in the boycott were domestic workers who didn't own cars and relied on the bus system for their jobs. In addition to driving them herself, Lacey was an enthusiastic fundraiser for taxi drivers who supported the boycott by offering free or discounted rides to these boycott participants. She sent letters all over the country seeking donations to help with the maintenance of the taxis. And let's not forget these two women. This is, you see, Irene West and Aretta Adair. They were also instrumental in coordinating the boycott. Let's talk about Thelma McWilliams Glass, born 1932. She was a secretary of the Women's Political Council, which she joined in 1947, and she passed out flyers, alerted the community, and urged passengers to walk or carpool during the boycott. And she soon noticed that every bus that went by was empty of passengers. And although there was sometimes violent retaliation against African Americans who crossed the boycott line. The boycott continued to end also by white people who would attack the people that weren't taking the buses. The boycott continued to demonstrate African American organizing power. Now, some segregationists retaliated with violence. Black churches were burned, and both Martin Luther King and E.D. Nixon's homes were destroyed by bombings. Still, further attempts were made to end the boycott. The insurance was canceled for the city taxi system that was used by African Americans. Black citizens were arrested for violating an antiquated law prohibiting boycotts. Shortly after beginning the Montgomery Bus Boycott in December 1955, Black community leaders began to discuss filing a federal lawsuit to challenge the city of Montgomery and Alabama bus segregation laws. They sought a declaratory judgment that Alabama state statutes and ordinances of the city of Montgomery, providing for and enforcing racial segregation on privately operated buses, were in violation of 14th Amendment protections for equal treatment. In response, members of the African American community took legal action. Armed with the Brown versus Board of Education decision, which stated that separate but equal policies had no place in public education, a Black legal team took the issue of segregation on public transit systems to the U.S. District Court for the Middle District of Alabama, Northern Montgomery Division, and Parks' attorney, Fred Gray, filed the lawsuit. So on February 1st, 1956, Fred Gray, the attorney for the Montgomery Improvement Association, filed a lawsuit in the U.S. District Court on behalf of 5 Black women who had been the victims of discrimination on local buses, joined by Thurgood Marshall and Robert L. Carter of the NAACP Legal Defense Fund. So let's take a look at Browder versus Gale, 142 F sub 707, 1956, civil action number 1147, Alabama Middle District Court, Northern Division, May 11th, 1956. So Browder versus Gale was filed listing 5 plaintiffs: Aurelia Browder, Claudette Colvin, Susie McDonald, Janetta Reese, and Mary Louise Smith. Now, Browder was picked as the lead plaintiff because of her age. 2 of the other plaintiffs were teenagers, and the other 2 were senior citizens. And Aurelia was 37 at the time, putting her in the middle of the other plaintiffs, and she was a good representation for all of them. Janetta Reese, sometimes they call her Jeanette, withdrew from the case soon after it was filed. She had originally been a plaintiff in the case, but intimidation by members of the white community, we still don't know who, caused her to withdraw her case in February. She falsely claimed that she had not agreed to the lawsuit, which led to an unsuccessful attempt to disbar Fred Gray for supposedly improperly representing her. William A. Gale, the mayor of Montgomery, was the namesake defendant, along with Montgomery's chief of police, Montgomery's board of commissioners, Montgomery City Lines, 2 bus drivers, and the Alabama Public Service Commission representatives. I will now read the transcripts of their testimonies. So now I'm going to read directly from the transcripts of Browder versus Gale. Plaintiffs and the defendants: Aurelia S. Browder, Susie McDonald, Claudette Colvin, Mary Louise Smith. The attorneys here as well for the plaintiff, led by Fred Gray, Charles D. Langford, Robert Carter. Let's look at the first transcript. This is Aurelia Browder, called as a witness, first being duly sworn, testifies as followed. This is the direct examination. Mr. Gray. Okay, remember, that's Fred Gray, her attorney. Mr. Gray says, and I'll use 2 different voices so you can differentiate between the questioning. State your name, Miss Browder. Aurelia Browder. Where do you live? 1012 Highland Avenue. Prior to December 5th, 1955, did you live here in Montgomery? Yes. Prior to December 5th, 1955, did you ride the city buses? Yes, 2 to 4 times a day. Have you been riding those buses since December 5th, 1955? No. Why did you stop riding them? I had stopped riding because I wanted better treatment. I knew if I would cooperate with my color, I would finally get it. Have you personally experienced any difficulty on the bus in connection with the seating arrangements? Yes, several times. Will you please tell the court what happened? April 29 of last year, I was on the Day Street bus. I got a transfer from Oak Park bus in front of Price Drugstore, going out to get the dry cleaners where I would get on Court and Day. After I rode up by the Alabama Gas Company, bus driver had 3 of us to get up and stand to let a white man and a white lady sit down. When you say 3 of you, do you mean yourself along with 2 other Negroes? Myself and 2 other Negroes. I was sitting in a seat and another lady beside me. And the seat just across from me, there was just one colored person in there. And he made all 3 of us get up because he said we was in the white section of the bus. If you were permitted to sit any place you wanted on the bus, would you be willing to ride again? Yes, I would. That is all. So that's Fred Gray at the end of Aurelia Browder on the witness stand. Okay. And then Judge Reeves says, you may arrange to cross-examine. And then the attorney for the Public Service Commission has no questions to ask this witness. And then Mr. Nabe for the defendants. You say you stopped riding the buses about December 5th, 1955. Is that correct? Yes, sir. And I believe you said you stopped riding at that time because you wanted better treatment. Is that correct? That is right. It is a fact, is not, that at that time the Reverend King and several others, so-called Improvement Association, I believe, made such a demand. Is that right? No. They did make some requests, did they not? I would not call it that. What would you call it then? We, the Negroes, request the Reverend King and not he over us. You didn't understand my question. Did Negro King ask three certain things at that time, did he not? One was, you said, for more courteous treatment on the part of the bus drivers. That is correct, isn't it? The Reverend King did not ask that. The Negroes asked that. Very well. But he was the mouthpiece for the Negroes, was he not? We employed him to be our mouthpiece. I see. And that is one of the things you asked for. That is correct, is it not? That is correct. And then you asked for seating, first come, first served, didn't you? Yes. And then you asked for the employment of Negro drivers. That is correct, isn't it? Yes. And you said unless you were granted all three of them, you would not return to riding on the bus. Is that correct? Yes. In other words, you did not stop on account of segregation, but you stopped riding before segregation issue was ever raised. That is correct, isn't it? It is the segregation laws of Alabama that caused all of it. Just answer the question. Isn't it a fact that your mouthpiece took into? No, he did not put it into us. Is it not true that he put into the newspaper a statement of his requests, and he specifically stated in that the segregation statutes were not involved? Do you know that? Didn't you read what he put in the papers? Yes, I did. And that was in there, wasn't it? Yes. And also your attorney sitting here, Attorney Gray, also at the meeting where they held it to adjust the differences, put out a mimeograph statement that the segregation laws were in effect. That is correct, isn't it? Yes. And you had the bus boycott on at that time. That is correct, isn't it? That is correct. We have no other questions. Mr. Thrun of the Montgomery City Lines has no questions. Susie McDonald now is sworn in, being duly sworn, testifies as follows. Direct examination. Fred Gray takes a stand here. State your names to the court. Susie McDonald. Where'd you live? Live on Cleveland Avenue. How long have you lived in the city of Montgomery? All of my life. About how long is that? 77 years. Did you ride the city buses here in the city of Montgomery back prior to December 5th, 1955? Yes, twice and sometimes 3 times a day. Have you rode the buses since that time? No, I haven't. Why did you stop riding the buses on or about the 5th of December, 1955? Well, I stopped because we were asking for it, but we didn't expect to get it. We didn't. We all had to stop, so I thought I would stop too. Would you ride the buses if segregation was eliminated on the buses? Yes. Were you involved in any incidents on the bus? Only I had to get up and let some white people sit down. I was asked to move. You were asked to get up? Yes, by the Cleveland Avenue bus driver. I didn't know who they are. They asked me to move. I had to get up. That is all. Mr. Patterson, no questions. Cross-examination, Mr. Nabe, for the defendants. You heard the questions which I asked a few minutes ago of the preceding witness, didn't you? I heard some of them. I see. Reverend King was the one that the Negroes appointed to represent them, wasn't he? I couldn't tell you very much about that. Now, when they stopped riding the buses, it was December 5th, 1955, was it not? Yes, sir. At that time, there was no agitation of any type among the Negroes for a change in segregation laws or an interpretation of them. Was there? Well, there wasn't any court orders, but we have been mistreated all the time. That is not the reason you stopped riding the buses. Attorney Langford, Your Honor, I think all these questions are irrelevant. It is not what the Negroes of Montgomery have done or will do is not the issue in this case. The question is whether or not this particular person is one who has been injured in being subjected to segregation. Judge Reeves, you have alleged the people stopped riding the buses for a particular reason, and if segregation laws were declared in the matter, they would commence. I overrule your objection. Back to Mr. Nabe. The bus boycott, then, was started prior to that time, and you stopped riding the buses prior to the time any reference was made to any change in the segregation laws or the anticipation of it. I didn't stop prior to that time. I had to. I was sick and I couldn't go. But prior to it, I had often been mistreated. You then stopped riding the buses because of ill health, was it not? No, not altogether. I was mistreated, was why I had to stop. Well, was it former years that you were mistreated? Yes, I was mistreated just a few months before the boycott. Well, you didn't stop at that time, did you? No, sir. You stopped at the time there was agitation among the Negroes to stop, didn't you? Well, I don't follow the others, but I reached my own judgment. I stopped because I thought it was right and that we were mistreated. But you stopped at the same time the others stopped, didn't you? Yes. And at that time, they made a public announcement of their grievances against the bus company. That is right. And their grievance at that time said they wanted more courteous treatment. That was one of the main things, wasn't it? Yes, sir. And that had nothing whatsoever to do with the segregation issue, did it? That is what we asked for. We didn't want no social equality. We wanted what we asked for. We wanted recognition. I see. In other words, you stopped. You did not want equality of any type, but you merely wanted recognition. That is right. No further questions. Redirect. Mr. Gray. Question. Will you ride the buses if segregation is removed? Mr. Nave. We object to that question. Judge Reeves. She has said that she will. That is all. You may come down. Now, Mary Louise Smith, next witness, being duly sworn, testified as follows. Direct examination. Mr. Langford takes it. State your name. Mary Louise Smith. Where do you live? 201 Broadway, Chisholm. What is your age? 19 years old. Who are your parents? Frank Smith. That is your father? Yes. Is your mother living? No. Then he resides at the same address you gave a moment ago? Yes. You are one of the plaintiffs in this case? Yes, I am. You are one of the persons who had some incident that occurred before the suit started? Yes. Do you at the present time ride the city buses? No, I don't. How long has it been since you rode the city buses? I rode it twice a day before this happened. Which happened? Before December. Before December 5th, 1955, you rode it 2 days before then. I rode it daily before then. You haven't ridden since? No, I have not. You stopped riding the buses as of that day? Yes. Now, prior to that time, have you had anything to happen to you in any way or any incidents? Yes, I have. Will you tell the court just what happened? This particular incident took place on Highland Avenue bus on October 21st, 1955. I was riding this bus, and I was sitting on the bus side reserved for white and colored. I was sitting behind the side that said for colored. At this particular moment, a white lady got on the bus, and she asked the bus driver to tell me to move out of my seat for her to sit there. And he asked me to move 3 times, and I refused. So he got up and said he would call the cops. And he asked me to move. I told him, I am not going to move out of my seat. I am not going to move anywhere. I got the privilege to sit here like anybody else. And so he said I was under arrest, and he took me to the station. You were arrested at that time? Yes, sir, I was. What happened after that? Well, they arrested me, and they kept me in jail for about 2 hours or longer, and then they charged me $5 in the cost of court. You were subsequently tried in the city court? Yes. And they fined you how much? $9. As I understand it, the bus on which you were riding had a sign, white on one side and colored on the other. Yes. The card said this side for white and an arrow pointed to the back for colored. As I understand it, that in effect was a segregated bus. Yes. That incident happened perhaps because you did have segregation. Yes. You are a Negro, and you were required to move from that seat to allow a white woman to sit down. That is right. Had it not been for the rule, no, I'm sorry, I will ask you this. Do you know what you were convicted of at the time they took you from the bus? Mr. Name. We think the record will speak for that. We object to that. We would like for the records to be introduced unless she knows definitely what she was convicted of. We will furnish them any records they want. Mr. Langford says, I asked her if she knew. Do you know what you were convicted of? Judge Reeves says, just answer yes or no. No, I don't. You are in favor of segregation on the bus lines, are you not? Yes, I was. Would you ride the bus again if the laws were changed? I would ride the city buses provided we had no segregation on the buses, on the city buses. Now comes the cross-examination, Mr. Nabe. You said you were convicted back in October 1955. October 21st, 1955. Did you have a lawyer at that time? No. You didn't have any lawyer at all. You did not have lawyer Gray here or no other lawyer. No, sir. You didn't take your case up? You didn't appeal your case, did you? No, sir, I did not. You were not interested at that time in the question of segregation, were you? I have been interested all my life Because I have grown up in a period. When did you first employ Attorney Gray in this case? Attorney Gray, I object, Your Honor. When she employed me has nothing to do with it. That is irrelevant. Mr. Nave, one of our contentions is that all this is one scheme and plan. These people have the opportunity when this woman was in there to have tested everything that they asked for today. And we are trying to find out if at that time she was in contact with him and why it couldn't have gone on up in the usual course of procedure. Attorney Gray, Your Honor, whether or not she decides to exhaust the state judicial remedy under the federal code is a question of law and not a question of fact. Judge Reeves, sustain the objection. Now, you said on this incident you mentioned here, he said you are under arrest. Now, who is he? Policeman. The policeman of the city of Montgomery? Yes. It was not anybody on the city lines, is that right? Yes, sir. It was not the driver of the bus, was it? Yes. He first tells me to get up and move. I asked you one question. You said someone said you were under arrest. Are you riding free at this time? No, I am not riding at all. You are not riding any of the free buses that the churches are all furnishing you? We don't have no free buses. Do you mean you pay for the buses when you ride on them? What bus? These station wagons. No, we ride those free. Now, you are riding those free then, aren't you? Yes, I am. All right, now, you said you stopped riding on December 5th. Why did you happen to decide on that particular day? Well, I think one person has been treated wrong and somebody else has been treated wrong. I just feel like I want to cooperate and do what I can to help them. You say that you feel you should cooperate. Who are you cooperating with? With the colored people of Montgomery. Did you get together and agree to stop riding on December 5th? No, we didn't get together. We just stopped ourselves. You must have had a meeting. Who gave you instructions to stop on December 5th? Did one say to the other, I'm going to stop riding, and everybody at one time stopped? They must have said because nobody went back on the bus. Now, somebody said, let's stop on a certain day. Now, who was that? I really don't know. But that was at the time when you had your first negotiations with the bus company in the city, wasn't it? That you stopped. Is that correct? That was on December 5th. That is the time you stopped riding the buses, wasn't it? Yes. And at that time, nothing was said about segregation whatsoever, was there? Something has been said about segregation as long as I have been living. I have known myself. You didn't represent to anybody anything about segregation, did you? To any of the officials at all? Well, I still just answered the question. You yourself did not at any time say anything about segregation to any of the officials, the city officials, did you? I did not say anything to them. As a matter of fact, Reverend King represented you, didn't he? No, he doesn't represent no one. We represent ourselves. We appointed him as our leader. You appointed him as your leader, our leader. But he did all represent the colored people. He was a spokesman for the colored people. That is correct, is it not? Yes, in his assistance. That is all. Attorney Gray, you do object to segregation now? Yes, I do. Do the rest of the Negroes in the Montgomery section object to segregation? Yes, they do. Mr. Dave, we object. Judge Reeves, overruled. Mr. Gray, that is all. Now, Claudette Colvin is called as a witness, being duly sworn, testifies as follows. Here's the direct examination. Fred Gray, attorney for the plaintiff. Question, state your name. Claudette Colvin. What is your address, Miss Colvin? 658 Dixie Drive. How old are you? 16. Who are your parents? C.P. Colvin and Marianne Colvin. You are one of the plaintiffs in this lawsuit. Yes. Prior to December 5th, 1955, last year, did you ride the city buses? Yes. How often did you ride? Twice a day. Twice a day? Yes. Have you rode the buses since then? No. Did you have any incident at any time while you were riding the buses? Yes. When did this incident occur? March 2nd, 1955. What bus did you ride? Highland Gardens. About what time was it? About 2:30 p.m. Where were you on the way to? I was going home from school. Will you please tell the court exactly what happened on March 2nd, 1955? I rode the bus as it was turning in on Perry and Dexter Avenue, and me and some other school children, I sit on the seat on the left-hand side, on the seat just above the emergency door, me and another girl beside me. You say another girl was sitting by you and another girl was sitting across from you. Do you mean those two girls were Negroes? Yes, sir. And he drove on down to the next block, and by the time all the people got in there, he seen there were no more vacant seats. He asked us to get up, and the big girl got up, but I didn't. So he drove on down into the square, and some more people boarded the bus. So Mrs. Hamilton, she got on the bus, and she sat down beside me, and that leaves the other seat vacant. You mean that from across the aisle, the other two girls had gotten up when the bus driver requested them to? Yes, sir. So he looked back through the window and he saw us, and he was surprised to see she was sitting down too. He asked her to get up then, and he asked both of us to get up. She said she was not going to get up. She didn't feel like it. He drove on down to the next corner or block rather, and when he got up and asked us to get up, and she told him she was not going to get up, that she paid her fare, and that she didn't feel like standing. And so he asked me to get up, so he directly asked me to get up first, so I told him I wasn't going to get up. He said, if you're not going to get up, I will get a policeman. So he went somewhere and got a policeman. The first policeman came in the back way and asked who it was. So he told the policeman who I was. Anyway, he said, why are you not going to get up? He said, it is against law here. So I told him that I didn't know that it was a law that a colored person had to get up and give a white person a seat when there were not any more vacant seats and colored people were standing up. So he got off. And then two policemen came in. He said, who is it? And he was very angry about it. He said, this is not new. I had trouble out of that thing before. So he said, aren't you going to get up? He didn't say anything to Mrs. Hamilton then. He just said it to me. He said, aren't you going to get up? I said, no. He saw Mrs. Hamilton, but he was afraid to ask her to get up. He said, if any of you are not gentlemen enough to give a lady a seat, you should be put in jail yourself. And so Mr. Harris, he got up and gave her a seat and immediately got off the bus. He said, you can have that seat. I am getting off. And so she taken his seat, and I didn't have a seat. So he asked me if I was not going to get up. I said, no, sir. I was crying then. I was very hurt because I didn't know that white people would act like that. And I was crying. And he said, I'll have to take you off. So I didn't move. I didn't move at all. So I just acted like a big baby. So he kicked me and got on one side of me and got on the other arm, and they just drugged me out. And I was so very pitiful. It really hurt me to see that I had to give a person a seat when all those colored people were standing and there were not any more vacant seats. I had never seen nothing like that. Well, they take me on down. They put me in a car, and one of the motorcycle men, he says, I am sorry to have to take you down like this. So they put handcuffs on me through the window. After that, where did they take you? They taken me to the city hall. While you were at the city hall, did anyone ask your age? Yes, they asked my age and everything. Where did you go from the city hall? I went to the city jail. Did they mention anything to you about taking you to the detention home, the juvenile court, instead of the city jail? Yes, sir, one of the policemen. So they took you to the city jail? Yes, sir. How long were there? It was over an hour. What happened when you got to the city jail? Well, all the people were staring at me and asked me what was wrong. One of the policemen said she didn't want to sit back there with the Negroes. And so he said, if any more of them act like that, she was the only one that didn't want to move back. So they put me in the cell and locked the door. And you stayed there until your parents came and made bond? Yes, sir. Were you tried later in juvenile court? Yes, sir. Were you tried for violating the segregational laws? Mr. Nabe says, we object unless she knows. Mr. Gray, he says, do you know whether you were tried and convicted of violating the segregation laws? I was. Mr. Nabe, we object to that question. We would like for him to ask her what she was convicted of. There are several segregation laws. Judge Reeves says, you can ask her if she knows what she was convicted of. Mr. Gray says, do you know what you were charged with? Yes, I do. What were you charged with? I was charged with violating the city code or certain sections of the city code. Do you know whether or not that section was amended at the time of the trial? I really don't know. But you were convicted. Yes, I was. And if you were able to ride the buses here in Montgomery without being segregated on them, would you still be willing to ride? No. Would you be willing to ride the bus if you could sit any place you wanted on them? Yes, sir. From your observation of your friends and your neighbors in your community, would they be willing to ride buses if they could sit any place they wanted to? Yes, sir. Now comes the cross-examination for the defendants from Mr. Nabe. You have changed, that is, you and the other Negroes have changed your ideas since December 5th, haven't you? No, sir, we haven't changed our ideas. It's been in me ever since I was born. But the group stopped riding the buses for certain named things. That is correct, isn't it? For what? For certain things that Reverend King said were the things that you objected to. No, sir. It was in the beginning when they arrested me, when they seen how dirty they treated the Negro girls here, that they had began to feel like that all the time, though some of us just didn't have the guts to stand up. Did you have a leader when you started this bus boycott? Did we have a leader? Our leaders is just we ourselves. We are just a group of people. Did you select anyone to represent you like Reverend King? We did select, quite naturally. We are not going to have any ignorant person to lead us, and we have to have someone who is strong enough to speak up, someone with intelligence enough. We have got to have someone who can stand up and who knows the law and who knows it is quite natural that we are not going to get up there ourselves, and some of them can't even read or write, but they knew they were being treated wrong. Is Reverend King the one you selected? We didn't select him. You said you selected somebody who was better informed to represent you. Now, who did you select? Well, I don't know anything about selecting, but we all just got together. But somebody spoke for your group, and now, who was it? I don't know. We all spoke for ourselves. Now, just a minute ago, I understood you to say that you selected somebody that knew the law better. Now, who was that person? We knew the laws better. Now, a lot of people know the laws better. Now, you are trying to say that Reverend King is the leader of the whole thing? I am merely asking if Reverend King was one of the leaders who represented you at that time, or one of the leaders who represented your group at that time and expressed to the city commission what the Negroes wanted. Probably he was one of them who went to the city commissioners, but I don't know. You don't know it all then? I don't know nothing. Now, was Attorney Gray here one of those whom you felt knew the laws? Yes, quite naturally. He's a lawyer. Now, did you know at that time that he sustained that the state law didn't apply at all to the city of Montgomery? What did you say about the state laws applying to the city of Montgomery? Did you know that is what he was saying at that time? I go to school myself, and I know there's a lot of law, national law, state law, and local law. Why did all of you stop riding on December 5th? Because we were treated wrong, dirty, and nasty. Now, the reason you stopped riding was because you had 3 things you asked. Is that right? 3 things we asked. Yes, we would still be treated the same way if we were to ask for these things. At that time, didn't you have in the paper an advertisement that represented your group, who spoke for your group, and you set forth 3 things that you felt were the things that caused the boycott? The thing that caused the whole boycott, Reverend King caused the whole trouble. Mr. Langford, if the court please, I would like to interpose an objection to the question for the reason that the question is irrelevant, and goes back to NABE. Reverend King said the Improvement Association published in the Advertiser, did it not, a statement of the things you wanted in order to stop the bus boycott? Did or did he not? Yes. And those 3 things that he asked for, first, more courteous treatment. Is that correct? Yes. And the second thing he asked was for seating from back to front for colored people and from front to back for white people. Is that correct? I don't know about that. And then that's the end of the testimony for Claudette Colvin. On June 5th, the judges released their decision. Segregated buses violated the equal protection and due process guarantees of the 14th Amendment and were therefore unconstitutional. The city of Montgomery could not enforce any law which may require plaintiffs or any other Negroes similarly situated to submit to segregation and the use of bus transportation facilities in the city of Montgomery. In June of 1956, the district court declared racial segregation laws, also known as Jim Crow laws, unconstitutional. And the city of Montgomery appealed the court's decision shortly thereafter, but on November 13th, 1956, the U.S. Supreme Court upheld the lower court's ruling declaring segregation on public transport to be unconstitutional. Here's the press conference afterwards. So both the city and the state appealed the decision, and on December 17th, 1956, the Supreme Court upheld the ruling, issuing a court order to the state of Alabama to desegregate its buses. So while the Montgomery bus boycott sparked by Rosa Parks gained lasting national attention, it was Browder's court case that resulted in segregation laws being declared unconstitutional. And with the transit company and downtown businesses suffering financial loss and the legal system ruling against them, the city of Montgomery had no choice but to lift its enforcement of segregation on public buses, and the Montgomery bus boycott ended after 381 days, officially on December 20th, 1956. The combination of legal action backed by the unrelenting determination of the African American community made the Montgomery bus boycott one of the largest and most successful mass movements against racial segregation in history. Although she had become a symbol of the civil rights movement, Rosa Parks suffered hardship in the months following her arrest in Montgomery and the subsequent boycott. She lost her job at the department store, and her husband was fired after his boss forbade him to talk about his wife or their legal case. Unable to find work, they eventually left Montgomery and moved to Detroit, Michigan, along with Rosa's mother. There, Parks made a new life for herself, working as a secretary and receptionist in U.S. Representative John Conyers' congressional office. In 1987, with longtime friend Elaine Eason Steele, Parks founded the Rosa and Raymond Parks Institute for Self-Development. The organization runs Pathways to Freedom bus tours, introducing young people to important civil rights and Underground Railroad sites throughout the country. In 1992, she published her story, Rosa Parks' My Story, an autobiography recounting her life in the segregated South. And in 1995, she published Quiet Strength, which includes her memoirs and focuses on the role that religious faith played throughout her life. In 1998, the hip-hop group Outkast released a song, Rosa Parks, which shot up to the top 100 on the Billboard music charts the following year. The song featured the chorus, "Aha, hush that fuss, everyone move to the back of the bus." In 1999, Rosa filed a lawsuit against the group and its label alleging defamation and false advertising because Outkast used Rosa's name without her permission. And Outkast said the song was protected by the First Amendment and did not violate Parks' publicity rights. But on April 14, 2005, the case was eventually settled. Now, at age 81, Rosa was robbed and assaulted in her home in central Detroit on August 30th, 1994. The assailant, Joseph Skipper, broke down the door but claimed he had chased away an intruder. He requested a reward, and when Parks paid him, he demanded more. Parks refused, and he attacked her. Hurt and badly shaken, Rosa called a friend who called the police. Now, a neighborhood manhunt led to Skipper's capture, and Rosa was treated for facial injuries. And Rosa said about the attack on her by the African-American man, quote, "Many gains have been made, but as you can see, at this time, we still have a long way to go." Skipper was sentenced to 8 to 15 years, and Rosa moved into the Riverfront Towers, a secure high-rise apartment building, and Little Caesars owner, Mike Ilitch, he also owned, I believe, the Detroit Red Wings, offered to pay for her housing expenses for as long as necessary. On October 24th, 2005, Rosa quietly died in her apartment in Detroit at age 92. She had been diagnosed the previous year with progressive dementia, which she had been suffering from at least since 2002. Her death was marked by several memorial services, among them lying in honor at the Capitol Rotunda in Washington, where an estimated 50,000 people viewed her casket. She was interred between her husband and mother at Detroit's Woodlawn Cemetery and the chapel's mausoleum. And shortly after her death, the chapel was renamed the Rosa L. Parks Freedom Chapel. Now, Parks received many accolades during her lifetime, including the Spingarn Medal, the NAACP's highest award, and the prestigious Martin Luther King Jr. Award. On September 15, 1996, President Bill Clinton awarded Parks the Presidential Medal of Freedom, the highest honor given by the United States executive branch. And the following year, she was awarded the Congressional Gold Medal, the highest award given by the U.S. legislative branch. Time magazine named Rosa Parks in its 1999 list of the 20 most influential people of the 20th century. And in 2000, Troy University created the Rosa Parks Museum, photographed lower right, located at the site of her arrest in downtown Montgomery, Alabama. And in 2001, the city of Grand Rapids, Michigan, consecrated Rosa Parks Circle, a 3.5-acre park designed by Maya Lin, an artist and architect best known for designing the Vietnam War Memorial in Washington, D.C. A biographical movie starring Angela Bassett and directed by Julie Dash, The Rosa Parks Story, was released in 2002, and that movie won the 2003 NAACP Image Award, Christopher Award, and Black Reel Award. February 4th, 2013 would have marked what would have been Rosa's 100th birthday, and in commemoration and celebration, the U.S. Postal Service developed a stamp called the Rosa Parks Forever Stamp and featured a rendition of the famed activist. Also in February 2013, President Barack Obama unveiled a statue designed by Robert Furman and sculpted by Eugene Daub, honoring Parks in the nation's Capitol building. He remembered Parks, according to the New York Times, by saying, quote, "In a single moment, with the simplest of gestures, she helped change America and change the world. And today she takes her rightful place among those who shaped this nation's course." Rosa Parks. That's my presentation. It's my seat. I'm John Horrigan. Thank you so much for watching.